Victoria Eta-Messi. Good morning, and thank you very much for joining us.
Good morning, and thank you for having me.
All right, the reports we're having, of course, is that they failed to meet the required numbers for the recall process to be initiated. But beyond that, I'd like you to elaborate on that, but also speak to some of the conversations about the potential of forged signatures and the image that it may have cast, or the aspersions may have casted on the integrity of those who were moving for the recall. Did INEC in any way confirm that these signatures were in any way valid, or is it strictly because of the numbers, the 43.8% that we're looking at here?
Okay, thank you once more for having me. So for a recall process to be adjudged successful, there are several steps that need to be taken. So if you go by the provisions of the Constitution, the Electoral Act 2022, and the guidelines and regulations of the Commission for a recall, it's clearly, the regulations in particular clearly spells out the steps that need to be taken. And so a petition is submitted. And this petition that is submitted would be supported by signatures of petitioners that want their member to be recalled. And like you rightly mentioned in the intro, they need 50% plus 1 signatures for that petition to be valid. And 50% plus 1 signatures for the Kogi Central recall to have been adjudged valid would have been 237,278 votes, signatures. And so a petition was submitted on the 24th. And this petition was supported with a covering letter. And that covering letter is signed by representatives of the petitioners. And so if you recall what happened last week, the Commission, having received the petition, noted that the covering letter did not have the contact details of the representatives. We needed to know who these representatives were. And if we needed, for ease of communication, it was important that we have their addresses and their contact details. And that was missing. And that was why in that first instance, the Commission again flagged it and said there was a problem with this petition. But within 24 hours, they were able to address that issue. They presented another covering letter that had their contact details. And then the Commission put out a notice notifying the member whose recall is being sought. Again, a notice was also sent to the presiding officer, that is the Senate President, notifying him of what was on the table with regard to the senator whose recall was being sought by her constituents, and the public was also notified. And after that, in that notification, it was stated that the signatures were going to be ascertained. That means that the Commission would take a look at all those signatures to even be sure that we had the number first. At this point, we're not looking at whether they are forged or whatever. Do we even have the numbers? And that was what the Commission did, and arrived at the press release that was brought out yesterday, that the petition did not meet the acceptable threshold. Because like we said, we needed 237,278 signatures. But the signatures that were submitted after the physical count amounted to 208,132. And that was 43.8% instead of 50% plus 1. So at that point, the Commission needed to bring out another notification, another press release stating that we could not go further. Because the Constitution clearly states that for us to conduct a recall, there must be 50% plus 1 signatures of constituents of the member whose recall is being sought. And so that was where we were as at yesterday.
All right.
After the physical verification, so to speak, of the signatures that were submitted.
All right, thank you very much for bringing, setting a background to the conversation. So I'm just going to reiterate another angle of my question, and why I brought the issue of forgery is because Nigerians were saying that it was logistically impossible for us to get that number of email addresses and phone numbers or signatures in 24 hours. And in your explanation, you did mention that in 24 hours they were able to rectify it. So from the perspective and the standpoint of INEC, knowing how, I mean, the challenges we experience in terms of conducting elections, being able to work with crowds and the like, is it logistically possible to be able to get over 200,000 votes, 200,000 details in 24 hours?
The contacts that were represented were not contacts of the petitioners, the 208,000 that they had. It was a contact of the representatives. So, for instance, you have 5 local governments that make up that senatorial district. So it is given or expected that each local government would have like a leader. So those were the representatives that signed the covering letter. So it was a covering letter that the commission initially flagged.
Okay.
And that was what corrected within 24 hours. The contact details of the representatives, their leaders, not these other petitioners, the main petitioners that appended their signatures to the petition.
All right. Thank you very much for clarifying that with us.
And again, going back to your other question about the possibility of being able to come up with all those signatures, that is the essence of the next step that we would have taken. The next step would have proven if actually there are human beings that own these signatures that were submitted, because the verification gives us the opportunity to go back to the constituency and to invite all those who signed the petition to turn up to be verified.
Very interesting. I mean, I think with these points that you've made, it sure has instilled a lot of confidence in many who are watching now, because that, out of the list, is the topmost question that has come from Nigerians looking at the current situation in Kogi State. But we'd like you to please stay with us. We'll go for a quick break. And when we come back, we'll take a look at some other aspects of this recall process and also look at one of the major indicators that has indeed sparked a lot of controversy concerning that story and, of course, INEC in itself. We'll be right back. Stay with us.
Welcome back to Breakfast Central, and we're having a conversation on the recall process that INEC just said that the petitioners didn't meet the threshold, so it's been thrown out. We're joined by a representative of INEC, and before we went to that commercial break, we're talking on a number of issues. But my question to you now, madam, is INEC spent quite a significant amount of resources on this recall process, sorting the documents and manpower and all of that. Do these petitioners have an opportunity to represent their petition? Or once a petition is thrown out, that's it? Or is there a period they have to wait for? Now that they know that they didn't meet the threshold, maybe they will try to get more signatures. What's INEC's position on this?
The law is actually silent on that. The law does not explain. So for now, we really do not know how that would pan out. But there's no provision for that in the law for them to go back and resubmit in the nearest future. But not that the other situation was that we needed the contact of 5 representatives. 5 people came and said, we are the leaders of the petitioner. So it was easy for us to say, oh, the letter that you submitted did not carry your contact addresses. And so that was easy to do. And they did that within 24 hours. But now you have submitted a petition signed by 208,000 petitioners who are constituents within the constituency of the member whose recall is being sought. And so what excuse would they give now? And where will they say they got the additional signatures from? So that's where it may be, that action may be questionable. But again, like I said, the law does not specifically explain or give room. There's no window for that they can go and come back within the shortest possible time to say, oh, we have made up the shortfall of the signatures that are being requested.
Thank you for clarifying that. But practically speaking, we know the law is silent on it. Administratively and practically speaking, what does this do to INEC, and what position would you, if you could advise on this process, if it should be repeated or not? What would be the ideal situation for everyone?
I don't think it is the place of INEC to ask them to represent. They know why they wanted or why they are requesting that their member, their representative should be recalled. But then it was also their responsibility to ensure that due diligence was applied when they were submitting or putting together their petition. Because the guidelines and regulations for the recall of a member of the House of a legislative house clearly states the steps that need to be taken. The Constitution insists that there must be 50% plus 1. The Electoral Act also insists that we must have 50% plus 1 in the case of area council members in the FCT. And so if they did not factor that while they were putting together the signatures, I think they can only hold themselves to blame for that. So the commission cannot ask them to go back and look for additional signatures. So who are the people that they are going to meet now? Are they going to start afresh? Those are the issues, because they cannot now bring another. The commission has put paid to this particular petition. It says it's not going to take any further action. So for them to act again, it means they need to go back to the field or to their constituency and get the signatures afresh. And like I said, the commission is silent, the law is silent on that. So I don't know how soon that can be achieved.
Okay.
All right.
I'd like us to look at one major issue that also came up during this entire, situation. There was a case of the Kogi Central Political Frontier, which happened to be the name that was pushing for this entire recall process. The CAC, as we heard, definitely came out and said that that particular company was not registered under the CAC. Let's see how this is linked to INEC. Does INEC also take cognizance into names in terms of company names or, a conglomerate that comes to, push for a recall process? And did INEC, was this entire process being pushed? Can you confirm to us it was being pushed by this same name, Kogi Central Political Frontier?
I don't think the name, whatever name that was used, would be an issue, because the law did not specify that it has to be a registered company. They just need to have a leader, because all of them cannot turn up at the INEC office. And so they would have representatives. So for the 5 local governments, they would most likely have one representative or one leader per local government. And I think that suffices. They just chose to give themselves a name. I don't think that was really necessary, because the law did not stipulate or specify that it has to be a registered company or a registered entity with the Corporate Affairs Commission that would represent them.
All right. There have been speculations about the fact that this recall was politically motivated. Is INEC concerned about the reason for a recall, and are there guardrails to ensure that the recall is not manipulated by opponents to destabilize elected officials?
Well, INEC cannot stop politicians from doing whatever they want to do, but all INEC has to do is to strictly follow the guidelines and the stipulations of the law. And mind you, a recall is not an easy process to achieve. Already we have there has been a lot of talk about the voter strength, the usual or regular voter strength in the recent past. And so for you to now arrive at the threshold that is expected of you in a recall is already a tall order. So that alone is I would say, sufficient check. So if you are able to achieve that threshold, then it means truly that the people want their representative to be called back.
Now, just to follow up on my colleague's initial question, could you clarify whether INEC was under any external pressure, either from political figures or government institutions, while handling this recall petitions? Because there's been accusations by a camp that INEC was biased and was teleguiding this group on how to go about the recall process.
INEC was not teleguiding the group, and INEC was not under the influence or guidance or control of anybody. INEC merely stuck to the rules. And the first time they submitted the petition, INEC just laid out what the issue was. There has to be a covering letter supporting the petition. And this covering letter that was sent, that was submitted to the commission, did not have the contact details of the representatives. And so if we needed to reach out to them or get back to them or share information with them, we had no way of getting through to them. And that was why INEC flagged that issue and said, we do not have the contact, and so we cannot progress with this. And in their wisdom, within 24 hours, they made their contact details available to the commission. And the law did not say that because they did not submit their contact in the first instance, that we should permanently stop the process. And so once they had submitted that, INEC had no choice but to continue with the process. And mind you, in all the steps that INEC had taken in this, it kept notifying the public. Every step that was taken, the outcome was put on its website. The member whose recall was being sought was also notified that a petition had been submitted by members of her constituents, and these were the actions that the commission was bound to take in line with the rules and regulations and the Constitution as well as the Electoral Act. So INEC was not being teleguided by anybody. It was merely following the dictates of the law.
Can you speak to the report about INEC receiving an interim injunction refraining INEC from proceeding with the recall process? We have reports here that the Federal High Court sitting at Koja granted an interim injunction restraining INEC from receiving or acting on any petition seeking to recall her pending the determination of the motion. So can you please speak to that?
I'm not aware of that ruling. I'm not aware of that ruling, but even if there was such a ruling, already INEC has said that it would not take any further action because the petition itself is flawed. Because it did not meet the acceptable threshold as specified by the Constitution.
All right.
So if they had actually met the acceptable threshold, I think I do not know the basis and the merit of that judgment. I am just hearing that for the first time. But the summary is that the petition did not meet the acceptable threshold, and so INEC has brought the process to its conclusive end.
Now, for voter education purposes, this is a hypothetical situation now. Let's assume it met the threshold. What's the verification process for those signatures, and what would be the next steps to having a successful recall?
Yeah, so if they had met the threshold, if the petition was supported by 237,278 signatures, INEC would have notified the member whose recall is being sought that we have, after physical confirmation of the signatures supporting this petition, they have met the 50% plus one. And so we are going to go ahead with the next step of the recall process. The presiding officer would also have been notified, the public would have been notified, and then INEC would now bring out a timetable for the verification exercise. And once a date is fixed for the verification exercise, the member whose recall is being sought has the opportunity to appoint her verification agents, because this verification is going to take place or would have taken place at all the polling units, that is 902 polling units in the constituency of Kogi Central. All right. And so once that would have been done, so the notice is put out, INEC on its own would have to engage the officials that would be used, that would serve in these polling units. So there would be verification officers that would be engaged and trained for the responsibility that awaits them at the polling unit. And again, the member whose recall is being sought would also have the opportunity to appoint her agents to represent or protect his or her interests in all the polling units. That's again for transparency. All right. And so on the date of the verification, all those who appended their signature on the to the petition must turn up to be verified.
All right.
So they'll be verified both manually and electronically using the register of petitioners as well as the beavers to confirm that these people that signed are actually human beings. So that is sufficient check for the fraud that you suspected or you were talking about.
Now we see why you've not been able to conduct.
You have had to come up to turn out for verification.
Right. I said now we see why we've not been able to conduct a successful recall here in Nigeria.
Exactly.
Thank you so much,
it's a long
Victoria Eta-Messi, Director, Voter Education and Publicity at INEC, for your time with us and for this very expository conversation. Thank you for your time.
Thank you so much.